Hello and welcome. My name is Robert Sterne and I am with the Washington, D.C. law firm of Sterne, Kessler, Goldstein Fox. The topic today that I would like to address is the critical issue of the decision maker's guide, as I call it, to the new contested proceedings under the America Invents Act. These are the new inter-party reviews and the new contested business method proceedings under the American Invents Act. Now, let's take it first, if we could, from the patent owner perspective, because that's where I think it needs to start. And before the patent owner begins or initiates any licensing or the filing of any suit in the district court or the International Trade Commission, they need to consider two options. First is the new supplemental examination proceeding that was created by the American Invents Act and became operational on September 16, 2012. Now, as of February of 2013, the date of this video, there have only been two of these supplemental examinations, much to the surprise of many of the drafters of the new law who thought that this new supplemental examination would be used by many patent owners going forward. And there are many reasons why this has not been more embraced. The important thing to know, however, is if you are a patent owner, that you may want to consider the new supplemental examination process if you've acquired a patent portfolio from another entity and want to deal with some critical issues that you have uncovered in that portfolio before you start to license or litigate. The other thing you need to consider as a patent owner is whether you should initiate, before the filing of the case or licensing negotiations, an ex parte reexamination. Now, the ex parte reexamination has been available to patent owners since 1981 and still exists under the new America Invents Act. Why would a patent owner consider this proceeding? For example, if a patent owner has been presented with or has gotten their attention to prior art that was not considered in the original examination that led to the patent, they could use the ex parte reexamination process as a mechanism to get that art considered by the examining court before they go out and license. Now, after the patent owner has begun licensing negotiations or after suit has been filed, the patent owner must be aware that there is a significant likelihood that as a retaliation, the target company will file one of these new contested proceedings. They probably will not file an ex parte reexam, as we'll talk about in a moment, but they probably will consider seriously filing either an inter party review or a covered business method proceeding against the patent that's being licensed or asserted against them in court. Now, the new post-grant review is not available as of the date of this video and will only become available for first inventor to file patent applications filed on or after March 16, 2013. So this consideration of what the retaliation could be is a critical feature that the patent owner must consider in bringing the suit. So now let's look at this from the perspective of the potential licensee or the accused infringer. In other words, the party on the other side of the legal V. This group must very carefully consider, as soon as suit is filed, whether they want to file an inter party review. The reason for this is there is only a 1-year window from when the suit is served on the defendant that the defendant can file one of these IPRs. And I've already been in situations where defendants have missed this window under the new proceedings. They should also consider a covered business method option if the patent that they are being sued on or being threatened with is one involving financial services or methods. And the Patent Office so far has taken a broad interpretation of the patents that are implicated by this new CBM option. There are several strategies that can be used with these new contested proceedings. One is called the pocket strategy, after the pocket complaint. And that one involves meeting with the patent owner or their agent before you file the new IPR or the CBM, and essentially make a presentation and say, if we cannot settle this case promptly, we're going to have to be forced to file this new proceeding. It not only saves money, but it gives the added option that once these things are filed, it is difficult to stop them. So there are advantages for the patent owner to reach a quick resolution before these proceedings are filed. And my recommendation is never to file these under most circumstances without a first meeting. Once they have been filed, they should be vigorously pursued, and settlement negotiations should occur at several junctures in the 18-month period that these new proceedings take. In addition, the defendant should seek a possible stay of the district court case, or perhaps even the International Trade Commission Section 337 case, so that the office can complete their patentability review under these new proceedings. And it seems that many courts, particularly with CBMs, will grant such a stay pending completion of this new proceeding. And throughout the whole process, as I said before, there needs to be negotiations going on between the parties to see if settlement can occur, because it's possible under the new law that these proceedings could be terminated as part of the settlement process, which are very attractive possibilities to the patent owner who are seeking to license or enforce the patent against multiple parties throughout the whole process. So I hope you have found this brief tutorial on this new world helpful. Understand that it is definitely a new world, and that all involved in patent enforcement and licensing should be well aware of how it works. Thank you very much.